The other part in the lender decision making is legal pressure. Legal pressure is where someone like me comes in, whereas I've buried the lender in discovery. I'm pushing, hey lender, let's take this thing to trial. I'm going to get my client off the hook from a deficiency. In theory, that should encourage the lender to, that leverage that I can use and build up over time in defending a foreclosure suit can be used towards getting the lender to do what my client wants them. Loan mod, which is a small percentage of my clients, or short sale or agreed final judgment of foreclosure. One of those two things, but legal leverage comes to bear. The last little category in my decision-making model, I would suggest that is the things that, like government intervention, where the government says, look, we bailed you guys out, modify some loans. We don't care what it does to your balance sheet, we're going to help you XYZ way. Another way that I recently have become aware of is a lot of the little bank closures in Florida, the smaller banks, even if they were relatively solvent. I would suggest to you that the government has, and specifically the FDIC, has gone in and said, we're going to put you guys out of business in order to help support the bigger banks. It's a little bit like, gee, we've paid so much money to bail out these big guys, we don't want to have them fall now. So it's kind of one of those things that, you know, how are your tax dollars and my tax dollars better spent? I'm not sure. One final thing regarding legal pressure. I have a client or two that was given a loan, let's say for $300,000. Her loan application showed, I have no income, I'm unemployed, I'm a college student, I've never been employed, but give me $300,000, 100% financing, I want to buy that house. Surprisingly enough, the lender says, here's your $300,000. So in that, and I'll explain how the legal pressure comes to bear in that case, I have a number of theories that I put forward being, look lender, you assumed the risk that this property might decline in value because you didn't rely on my client's occupation, her cash flow as the basis for repaying this loan. So by default, you relied exclusively on the property's value as your source of repayment. Therefore, because you relied exclusively on the property's value, you didn't base the loan whatsoever. You couldn't have based the loan on the cash flow because you exclusively relied on that property's value. You assume the risk that property values might decline, and so you shouldn't be able to pursue my client for a deficiency in that case. That's just one of, I have about 15 kind of theories and sub-theories that I put forward in defending a foreclosure suit that I'm a little bit of a prick and I give the lender heartburn.
You seem so mild. I know.
I try. So that's one example of legal pressure in trying to get the lender to do something that we want. Oftentimes, the legal pressure actually develops through the lender's attorney screwing up. Like a lot of the true legal pressure I've gotten is where the lender's attorneys just did something stupid. And you know, everybody does stupid things from time to time, but when they do something stupid, then I often get the pressure to get the lender to do what I want.